All right, the court will call McMillan versus McMillan.
Your Honor, may I have permission to address the court before oral argument?
May.
To ask
You may.
if my appeal be limited to the issues of CBA, accounts receivable, and husband's business interests?
I'm sorry, ma'am. Excuse me, ma'am. Who are you?
I'm the appellant.
Okay. Are you represented by counsel?
Yes, I am, but I don't want him to reopen equitable distribution, and I don't want him to
Okay.
reopen...
Is this your client, Mr.
No,
Pope?
no, it's my client, Your Honor.
Your client. Are you all having some sort of a disagreement about what you're going to argue today? Is that?
Yes.
Okay. Counsel, are you?
My point would be, as I've discussed with opposing counsel, my point would be to limit my argument with respect to accounts receivable and attorney's fees today.
So your client has directed you to limit the points on appeal to 2 issues?
That is the points on argument, Your Honor. If my client directs me in front of this court to limit the appeal in total to those points, other than the ones that were raised, that's...
Do you want to abandon the other issues, ma'am?
I do not feel it's safe to reopen equitable distribution or alimony due to concerns about possible health care provider fraud and corruption in the Sheriff's Office involving Stephen Salvo and Nancy James. I would further ask whether Judge Torpey could be recused due to his ties to Brevard law enforcement.
Okay, well, all right, well, let me address those one at a time, ma'am, okay? If you're directing your attorney to abandon some issues on appeal, then that's really between you and your attorney. As far as your request to recuse me, you have to file that in writing, and you have to do it through your attorney, and your attorney knows how to do that. And there's time limits, and there's specific rules that require a written motion. It has to be sworn, has to state the facts upon which you base your request to recuse a judge, and you can go over that with your attorney, and he can file that after the hearing. But right now, unless counsel's asking for me to recess this proceeding in order for you to be able to file a written motion, the court intends to proceed with the oral argument. Are you asking for a recess at this time in order to file a written motion to disqualify? You wish to confer with your client?
May I, Your Honor?
Sure, go ahead.
Thank you. My apologies, Your Honor.
No problem, sir. How did you wish to proceed?
I believe, if I'm clear from what Ms. McMillan's requests are, that I would request the recess. I will tell the courts honestly, I will be moving to withdraw as appellate counsel, which is rather unusual, I understand. Prior appellate counsel withdrew on this case before.
Are you requesting a recess for the purpose of filing a motion to disqualify me?
Yes, Your Honor. However, if I may clarify my position, I will personally not be moving to disqualify you.
Well, the court, I'm going to sua sponte recuse myself on the case, and I've notified the chief judge of our court that I'm sua sponte recusing myself, and he has appointed sua sponte Judge Monaco to hear the matter. So Judge Monaco will be here momentarily. Please stand in place.
Thank you, Your Honor.
Okay, counsel, you ready to proceed?
Yes, Your Honor.
Okay, you may proceed.
Thank you. And I apologize once again for the delay, Your Honor.
All right.
As I indicated before Judge Monaco got to the bench, the arguments that first of all, I'm Leonard Ross on behalf of the appellant. The arguments that I intend to raise today with respect to this matter are, number one, accounts receivable with respect to the equitable distribution scheme. In this case, the court dealt with an issue in which you had the husband who was a physician and belonged to a professional association, and there were accounts receivable with respect to that professional association. The accounts receivable in the particular case equaled, when you look at the net value of them, $1.3 million. So it's a sizable.
Let me ask you this. If there was a contract in place that governed the partnership arrangement, and if that contract said that none of the partners are entitled to an undivided share or divided share of the accounts receivable, all that they're entitled to is, if they ever leave the partnership, all that they're entitled to is the return of the capital contribution. Would that, under that scenario, would you have an argument for any right to equitable distribution of the accounts receivable? In other words, if the husband doesn't have a right to get there, why would the wife have it?
I still believe you would. And the reason I still believe you would, if there had been a contract, and obviously I think that's a somewhat different scenario than we have here, but directly in response to your question, I believe you would, because you don't have a scenario wherein the husband either is leaving the practice, is about to leave the practice, or has left the practice. And if we look at the point in time from the time
Well, the accounts receivable this month, that's the money from which salaries and expenses are going to be paid next month, correct?
Correct.
Okay. And if the salary is taken into account in everything that's done in the dissolution, then why isn't that a double dipping to say, well, we get all the money from which the salary is going to get paid, and now we're going to account the salary as well? It just doesn't make sense to me. If we're talking about a business valuation and he was a sole proprietor, that would make sense. But given his testimony that he has no right to the accounts receivable other than his right to his draw or salary and his right to a capital contribution return, I just don't see any basis for accounting for that as a separate asset.
Well, I think, number one, this Court's own ruling in Leani directly hits that point. And when you look at the value of a professional association, a medical professional association, accounts receivable are matters to be determined with respect to an asset for equitable distribution. Secondly, with respect to that, what you're looking at is at the time of filing the petition for dissolution of marriage. Presumably, one could make a salary in the meantime after the petition has been filed and not share it with their spouse at the time, who later becomes their former spouse, because you've got no duty to do so. And particularly, you have no duty here when you had no temporary order with respect to support. So that money is not necessarily double dipping. What has happened is, at the time, if you take a snapshot at the time the petition for dissolution of marriage is filed, and you say, okay, we've got out there $1.3 million, and that's there, and I don't have to share it with you because I don't have a duty to give you money during this period of time after the petition for dissolution of marriage is filed. Well, it's there, and it's there to be divided. We don't know if it's to be divided, quite frankly, based on the record on appeal, 8 ways or 11 ways, whatever the circumstances are. But based on the ruling of this Court in the Leani case, that is a marital asset. Otherwise, you've got a corporation, a very, very profitable medical business, which you say, look, there's no value. You don't get anything. That's it. But clearly, under this Court's own ruling, that has a very specific value.
Typically, though, one would evaluate the business, not necessarily the individual assets of the business. Right?
Correct.
You're going to have to forgive me, since, as you might have guessed, I don't know anything at all about this case.
No, I understand.
Tell me a little bit about...
Please forgive me for putting you in this situation, Your Honor.
It's not a problem. Tell me a little bit about the practice. Is it a one-person practice? Are there 14 people involved? Is it a...
There were anywhere from between 8 and 11 people at that time.
Or doctors?
Correct.
Which?
Doctors. I'm sorry, doctors. I apologize. There were doctors. Anywhere from 8 and 11, and the husband was rather nonspecific with respect to that direct question during the trial. And there were accounts receivable at that time.
Hold on.
Yep.
What is his relationship to the corporation? Is he a stockholder?
He's a
I
member.
assume it's
A member of the Association of Stockholder, correct.
Okay. Is he an officer?
You know, I don't know off the top of my head whether he's an officer, Your Honor, so I can't intelligently respond to that. What I do know is they had a deferred compensation package as well, so there was money as well to come out of that too, but I don't know the...
Yeah, that's a different kind of an issue, though.
Right, correct.
But, I mean, I can understand your position if you have a one-doctor office in which he's hiding his assets as accounts receivable. That's one point of view. But I don't know that you can begin to individually evaluate each of the assets of the corporation when it's not a body that is solely owned by him. I think don't you think, Mr. Ross, that what you have to do is to evaluate the value of those stock assets, since that's what he owns?
Well, Your Honor, in this court's opinion, which is the Leone case from 2003, you dealt with...
Was I on that panel?
Let me take a look, Your Honor. Judge Orfinger authored the opinion, and in that opinion, you dealt with a scenario wherein you had three members of also a medical professional association. So you've had three in total, the doctor being one.
It's a dissolution case?
Correct. And I see no difference from this case. In fact...
What was the holding in Leone?
In the holding, there is that the trial court should include the net value of the former husband's accounts receivable in determining the value of his medical practice, so that the trial court can distribute the assets in an equitable manner given the overall division of marital property.
Was there a contractual relationship between the doctor and that PA?
No, in fact, they distinguished it from another case which opposing counsel has raised, which was the Leone case, because there was another case in which they said there was a contractual relationship with a third party. When there's a contractual relationship with a third entity that controls the accounts receivable and collects the accounts receivable and then pays out to the doctor some set sum of money, that's a different story.
Did the doctor here have any kind of an employment agreement with the PA?
Yeah, there was an employment agreement that all of the physicians had, but it did not, in other words, it did not limit accounts receivable.
What is he entitled to upon dissolution of the corporation?
Upon dissolution of the corporation, I believe the figure was $66,000. If he, in other words, I believe it says if any member leaves the practice, they're entitled to that, but that is as deferred compensation. It doesn't directly reference accounts receivable, and that's.
But his testimony at trial was that all I'm entitled to is the $66,000 and whatever salary I've earned before I left that's unpaid. I mean,
and that's if he leaves, Your Honor.
Right.
And the reality of the situation is...
And if he stays, he can't go in and raid the accounts receivable account. I'm quite certain that in a corporate structure, none of the shareholders can... I mean, they have a right to get their salary paid, but And I think that goes back to your initial question, which is the heart of the matter. If you look at that snapshot at once the petition is filed, and you don't have to give any money to your spouse once that happens, he's getting that money. In other words, the trial court could say, wait a second, the accounts receivable at the time the petition is filed, we can look until the final judgment and we can say, well, you've got this windfall, you've got this $1.3 million of net profits, you've collected the money, you haven't left the practice, it's inapplicable as to whether or not, what happens if you do leave the practice.
Well, wait, accounts receivable are not net profits.
Well, this would be the net. In other words, this is the net. I apologize. I didn't mean net profits. Net accounts receivable. In other words, they're out of the 1.5 million that were the gross accounts receivable.
That's for the entire organization?
Yes, Your Honor. And there were accounts payable that equal 223,000 and change. So it came to 1.3 of the net accounts receivable.
But he's not entitled to all that. He's got 9 other partners or whatever.
Exactly. And that's what we're saying, that the trial court, on remand, the trial court would clearly have to say, look, you're not entitled to half of that, you're not entitled to all of it. What percentage are you entitled to? Here the trial court said a zero value.
And Mr. Ross, how can he do that? How can the trial court do that? What's the formula by which the trial court could come to a conclusion about what this gentleman is entitled to.
I think the trial court could say, we've got 8 members in this organization, and we've got a accounts receivable, which are $1.3 million. You're entitled to 1/8 of that amount. If they're
But that's not, the accounts receivable also have to take into account the continuing operations of the firm. You can't just, if you strip out all the accounts receivable, there's not a whole lot left to pay salaries or rent.
And I have absolutely no disagreement with the trial court doing what a trial court does in every case and saying, okay, what are you entitled to? The problem I have, in other words, I'm not saying there's this magic number. I'm saying the trial court must make that determination with argument, but can't come to a zero figure. A zero figure is contrary to this court's pronouncement in Leani.
I'll have to read Leani.
And that would be my point on that argument, Your Honor. With respect to the second argument concerns attorney's fees, my argument concerning that would be that the trial court in this particular case had dealt with a situation in which you have a physician, as we've indicated already, that's netting somewhere in the neighborhood of 21,000 plus per month. We have a spouse who is certainly mentally disabled, and there was an abundance of testimony with respect to that concerning the problems, and she is receiving alimony of less than $5,000 per month. And under the case law with respect to the matter, initially you've got sufficient disparity in the party's income after you look at the equitable distribution, requires a payment of attorney's fees, and that's under this court's opinion in Hill versus Hooten. And what the...
Well, what's the standard of review for that?
Abuse of discretion. Yes, Your Honor.
In this case, of course, the argument on the other side is that virtually all the cash assets went to your client, and there was cash left over available that she could use to pay the attorney's fees and have some still. And under those circumstances, I have a hard time finding an abuse of discretion. Now, the problem with the argument is that counsel on the other side is saying that that same money could be invested in order to make up the deficit on the alimony that is there because the trial court didn't factor in the monthly income tax obligation. But if you're withdrawing that issue, then...
I don't think obviously I'm not withdrawing any issue, Your Honor, as far as this goes. I know that the problems with respect to my client, but I think in that case...
We need to understand whether you are or not.
I am not, Your Honor. The problems...
There are no issues raised in your brief that you're withdrawing?
Correct.
Okay.
The liquidity argument I think that the opposing counsel raises is one to be considered under the case law as to the liquidity of the assets, but I think it's certainly relevant with respect to the fact that here you've got a situation in which obviously the husband comes out in far better shape because there are non-marital assets, and he's got an enormous salary. The wife has next to nothing and is obviously mentally disabled. And if I may reserve...
Certainly.
Thanks, Your Honor.
Ma'am, you need to sit down. You cannot address the court, and you'll be removed if you don't sit down and be quiet. You're speaking through counsel. Yes, sir.
Then could I have a continuation oral argument?
No, ma'am, you can... Okay, you can proceed, sir.
I'm sorry?
You can proceed.
Thank you, Your Honor. My name is Michael Poe, and I represent the appellee, Dr. McMillan. The two issues that they are raising, that they're arguing, and I'm confused, too, if I should argue the other issues, because they're saying that they're not going to argue them now, and she says to withdraw them, and so we're just arguing. There are two issues, but in any case, the two issues that they're arguing. Number one is the accounts receivable. The only thing he's entitled to is the $66,000.
Let me just say, someone who's represented can't address the court directly and can only speak through counsel, so at this point, there are no issues that are withdrawn, and you should address anything you want to.
Tell me about Leani and why it doesn't apply.
I'm sorry?
Tell me about the Leani case and why it doesn't apply here.
Well, Judge, in this case, what has happened is that the court made a determination, made a finding, that was not a marital asset. That was not his asset. Because he had...
Accounts receivable.
The accounts receivable. And the only thing that they did, the corporation had accounts receivables. He was not entitled to them. There was no question. There was a stipulation. This is what he gets, $66,000.
There was a stipulation?
If you look at all of the different items that we argued about in court, we stipulated to all different values on almost everything. $66,000 was the value of the corporation. That's what he was entitled to. At trial, all of a sudden he brings up the fact that, oh, there's these accounts receivable.
He being Mr. Ross?
No, I'm sorry, this was not Mr. Ross. This
Okay.
was Mr. Levin. Okay? And then all of a sudden, well, there's these accounts receivable, which he was not entitled to. We had talked with their counsel. We came up with this number, $66,000. That was it. That's what his entitlement was. That's on their exhibit, one of the exhibits of what the values of all the assets are, which we stipulated to most of them because they were mostly cash assets. At the trial, he brings up, oh, there's accounts receivables. Well, he's not entitled to them.
Well, let me see if I can further understand the relationship between, yes, it's Dr. McMillan and his,
Right.
and his corporation. Does he have an employment agreement?
Yes.
Does the employment agreement address the issue of accounts receivable?
It says that they're entitled to none. When he leaves, this is what he gets. They get nothing else. That's what it says.
Is that the way you would distinguish the Leone case?
Yes, Your Honor. And if the court were to say, if the appellate court were to say, okay, we have to consider accounts receivable, then the $66,000 goes out the window because, you know, he's not leaving, and so he wouldn't be paying that plus accounts receivables. Right? And then, assuming that their numbers are right, after paying taxes, just his taxes and nothing else, it's down to about $60,000 because he's in the 35% bracket. If there were 11 physicians, then he would be entitled, just looking at accounts receivable less accounts payable at that time, not ongoing expenses, not tax ramifications of him paying 35% of the taxes, it was $118,000. Now we have to, if you assume that they're going to collect all of the accounts receivable and there's no other expenses, then he would be entitled to $118 minus 35% for taxes, and that's assuming there's no other deductions whatsoever taken out, and the court can't do that. So it's really, we're not even talking about much of a differential, if any. And as a matter of fact, if they go back and look at it, it could be that she doesn't get half of the $66,000 because the accounts receivable, what he's going to get, if the court could determine what they would be, are going to be less than that. The other on attorney's fees is that during the course of the divorce, she received $78,000, and he did, of marital funds. That was not accounted for in the distribution because it was already distributed. The reason was she needed attorney's fees. So we divided two accounts so they both got the same amount. She had that to pay attorney's fees. She got $1.6 million in assets. About 400 of them were 250, 354, about 450 were real property. The rest of it, 1.2 million or so, was in cash and retirement funds. He received the real estate, one piece of property, which the court valued at $2 million after taking away the mortgage, etc. He owed her another $150,000. So her cash went from the $550 to almost $750, between $700,000 and $750,000 in cash assets. When the court made a determination as to investing money and how much money she would have, it didn't include that $150,000. 80-some thousand, and then the testimony was it was another $20,000 that she had paid. That should have been $100,000 that had already been paid to the attorney at that time. She received more than enough assets in order to pay her own attorney's fees. And this court has held regularly that if you receive enough assets, then you should pay your own attorney's fees. And she received enough assets throughout the course of the litigation. There was not one hearing on this matter in the 2 or 2.5 years that it went through, that we were going through the divorce for temporary relief or temporary attorney's fees, because it was all taken care of exactly the way it had been during the course of the marriage. So she always had the attorney's fees. She was given, like I said, $80,000. And the court didn't consider that in the equitable distribution either. She said that was already gone. They both received that. So when we're talking about the money that she received, there's another $80,000 that $79,000 that she received that the court didn't really consider in the equitable distribution. So she had more than enough money. Yes, he does make more money, but that's not the case law in the Fifth, and it never has been. That if you make more money, if there's an equal division, and you can both pay your own attorney's fees, if the party makes more money, then he should pay for it. The case, I think it was the Kelly case at this court, there was a big she received a couple $1 million in marital assets, as did he, but he had to pay some attorney's fees, but he had $8 million or $7 or $8 more in assets. So he had, $7 or $8 more in assets, and the court did say that he has to make a contribution. That was from the Fifth. But that's a big distinction here, because they both received the same, and she received all of the cash assets. Because he received no marital cash assets. As a matter of fact, had to come up with $150,000 to equalize the payments. So she has the ability to pay her own attorney's fees. I filed 2 counts on a counter appeal, and I'm going to just discuss one of those, and that is there was a $70,000 account at the time that the parties were filed for divorce. From that $70,000, she received in direct payment from him, I think it was $25,000, in $5,000, $5,000 to $10,000, and a $5,000 payment. He paid for the mediation of some $3,600, and he paid the income taxes during the 2 years that they were from this account, for a total of $48,000. The court used the $70,000 initially that was there at the time of the filing as the valuation of that. And so my suggestion is that was an error, because it was all used. She received $25,000 of the cash. He paid for the mediation for both of them, 2 different mediations, and the other with the taxes. And that should have been taken into
Are you still arguing that the value should have been $54,000 something?
Yes, sir. That's what I'm saying.
Okay. And with those 2 adjustments?
With those adjustments. That's what it got down to, and not the 50. It was, like I said, I think it was $25,000 that she received, $3,600 in cash, and $16,000 or $17,000 in income tax that he paid in 2 years from that account.
Okay.
I have nothing to say.
Your Honor, if it's necessary for me to fire my attorney to address the court, may I do so?
No, ma'am. You can proceed. Any rebuttal argument?
Your Honor, I'm just wondering, and I know this is rather unusual, as we said at the start, I'm wondering if I may now file an ora tennis motion to withdraw. Apparently, Ms. McMillan would like me to proceed in other ways, and I apologize to the court, as I indicated previously.
The motion's received and denied.
Thank
you're
you,
not
Your Honor.
relieved of your obligation. You have 6 minutes left if you want to use it.
Thank you, Your Honor. With respect to briefly with respect to the attorney's fees issue, I believe this court's relatively recent pronouncement on the matter in Kelly versus Kelly is instructive on that issue, and that is that a spouse should not be forced to liquidate capital assets to maintain a marital lifestyle or pay attorney's fees.
In this case, didn't the court, as best it could, divide the property equally with cash and distribution of real estate, even though there was a contest about the value of a parcel? Didn't the court divide the property equitably between the 2?
Obviously, based on the other points, I don't think that it was an equitable distribution, but it was the intent of the court, I think, to come up with an equitable distribution. Yes, Your Honor.
And did not she receive cash as well as property to pay attorney's fees and lifestyle, and the husband was ordered to pay alimony?
Ordered to pay alimony, correct, for her lifestyle, and I think that the court, in addition, said that the other assets should be used, because there should be an interest on the other assets, so that they could pay the rest of the amount of the funds that were needed for her support.
Looking at the file where the court divided the his and hers, is there a reasonable basis in the record to support what the trial court did, particularly as it relates to her mental health, her standard of living and the income the husband received and then the money he was owed to the wife to continue her lifestyle.
I don't believe that there was a reasonable basis. I believe that it was an incorrect decision, Your Honor.
But the review for us is abuse of discretion?
Correct.
All right.
Thank you, Your Honor.
Thank you very much.